It's time to start our panel. I'm happy to be a moderator in such large panel consisting of really well-known authorities in public international law and international criminal law, and it is like logical continuation and at the same time finalization of our conference. Its main topic is namely the idea that gathered us here. It is the special tribunal for the aggression against Ukraine, including all the particularities on jurisdiction, modes of establishment, composition, immunities, and many other issues. And I'm pleased, first of all, to introduce to you the first panelist, who is Professor Philip Sands, Professor of Law at University College London, also visiting Professor of Law at Harvard, practicing barrister at Matrix Chambers, who also appears frequently as a counsel before the International Court of Justice and other international tribunals, sits as international arbitrator. He is also an author of a number of books and articles, including articles in public press. And would you excuse me? I will not mention all of your books. We are really pleased to see you here today, and I would like to ask you to make a sort of introduction about the very idea which appeared in the combined statement and declaration, and the significance of tribunal to the whole system of international peace and security, maybe also the campaign for promoting this idea and preparation of its statute. Please.
Well, thank you very much for the generous introduction, and my thanks to the government of Lithuania for hosting this meeting and for inviting us. It's an incredible pleasure to be here. Some of us have been in touch, but only by Zoom, and to actually be physically together, it really is a wonderful thing. So we all know the day the war began, and about 36 hours after the invasion occurred, I received an email from the editor of the opinion pages of the Financial Times in London, for whom I occasionally write. She said, given your connection with Ukraine, given your book East-West Street and the origins of the concepts of genocide and crimes against humanity and the city of Lviv in western Ukraine, could you write 700 words for us on anything you want on Ukraine and international law? I spent about 24 hours thinking about it, and then literally 2 hours actually writing. And the subject that I focused on was what for me was a major gap in the delivery mechanism for the rules of international law that exist, and that concerned the crime of aggression. I did a little research on how I wanted to write the piece, and I focused, for those of you who've read the piece, by way of introduction, on a meeting that was held, probably quite similar to this meeting, in London on January the 13th, 1942, when a number of governments in exile from various European countries gathered and adopted a text that is known as the Declaration of St. James. The Declaration of St. James put forward the idea that perpetrators of crimes in Nazi-occupied Europe should be subject to punishment. And that idea, of course, then morphed into the United Nations Commission on War Crimes, Yalta, and in the summer of 1945, the London Agreement, that created the International Military Tribunal. When those individuals met in London on January the 13th, 1942, it seemed completely improbable that anyone would ever be in the dock. But just 3 years later, as we know, everything had changed. And that inspired me to propose in my opinion piece that there be created a special criminal tribunal to deal with the crime of aggression in relation to Ukraine. I must confess, if you had asked me at the time, would I expect to find myself just a few weeks later sitting at a meeting with such participants discussing the modalities, I would have said no chance. But once ideas get out there, we know they can run. Very shortly after the article appeared, 2 different sets of communities got in touch. The community around now my very dear friend Mikola, Professor Niatowski, with whom I've been in very close contact, but I've known for many years, who was the advisor to the Minister of Foreign Affairs of Ukraine, who shared with me that actually the minister, Mr. Kuleba, had actually written an article on the Declaration of St. James. There is an absolute synergy here in relation to the subject that we are talking about. And we talked, and around the time that we talked, I received another communication from a gentleman you heard from this morning, the former Prime Minister of the United Kingdom, Gordon Brown, who simply said, I read the piece, I'd like to help. I think this is an idea that should be promoted. I'll open my address book and get in touch, and some of the people are here as a consequence of that. It's one of the things that you don't know when you're not working in those echelons of government, that they all know each other. There's a sort of club of former presidents and prime ministers and senior characters, and they all arranged Zoom meetings with each other, and very soon things began to happen. The simple point is that one thing led to another, and did so very quickly. And it did so, I think, because people have understood a number of points, and I'll be very brief before we then open up. The first is, such a special tribunal has precedent. It has precedent in relation to a multilateral agreement between states, Nuremberg, Tokyo. It has precedent in relation to an agreement between Ukraine and an international organization, Kosovo, Sierra Leone. There are numerous other examples. Secondly, and most significantly, this is not like Nuremberg in 1945. There is substantive law. There is a crime of aggression, not only in international law, but in the law of Ukraine. In spending those few hours researching the article that I wrote, I came across, or I revisited the work of a very fine American scholar, Francine Hirsch, who'd written a wonderful book, which I think is worth getting and looking at, called The Soviet Union and Nuremberg. And from this, and then in conversation with her, I learned the idea of crimes against peace, as it was then called, but today crime of aggression, actually originated with a Soviet jurist, Aaron Trenin, who had to persuade the British, Americans, and French to insert it into what became Article 6 of the Nuremberg Statute. So there is a very direct connection, an attractive connection. And then after the Nuremberg Tribunal gave its judgment, the crime of aggression was integrated into the penal codes of the Soviet Union, Belarus, and Ukraine. In other words, that left the situation that essentially what we are talking about is an international delivery mechanism to assist Ukraine in prosecuting, investigating and prosecuting what is manifestly a serious violation of international law. It is not something that the ICC can do. It is something that Ukraine can do in its domestic law, but for very good reason, I think. This is the one thing that ought to be internationalized. Many of you will recall that the Nuremberg judgment described the crimes against peace, the crime of aggression, as the supreme crime. All the other crimes that were adjudged at Nuremberg flowed from the crime of aggression. And that is, in fact, exactly the same thing in this situation. If we did not have an invasion that was manifestly illegal, we would not be talking about war crimes or crimes against humanity, or even, as some are talking about genocide. And so that meant for me it was the ultimate crime in this dreadful situation that we now face, and that gap must be filled. 2 final points. The scenario that worries me greatly is that in 3 or 4 years' time we will find ourselves in a situation in which there are proceedings in national courts, Ukraine, Germany, Poland, other places, the International Criminal Court, certainly for war crimes, maybe also for crimes against humanity, but there's only a focus on mid-level or low-ranking people who may have committed crimes but are not the principal individuals responsible for what has happened. Those who took the decision, participated in the decision, supported the decision, financed the implementation of the decision, and so on and so forth. You're probably talking about 20 people. And the second point in relation to that is this crime of aggression is the only one, it is the only one with absolute certitude that you get straight to the top table. The other crimes may lead to the top table, but proving the involvement of Mr. Putin, Mr. Lavrov, the defense minister, and others in connection with some of the terrible things that we are seeing on our screens and that some of you have witnessed much more directly is possible, but it's going to be requiring a lot of energy. And my fundamental concern on justice and accountability is that it must reach the top table. If it does not reach the top table, it will be a failure. It is not sufficient to look at the lesser individuals who are behind this. And that was what I evoked in the piece, and it's a very great privilege to be on this panel with everyone this afternoon and with this distinguished audience to talk through the modalities of how we do that. Thank you very much.
Thank you very much, Professor, for an excellent overview. Indeed, we're going to explore many issues touched in your presentation. And now I am pleased to introduce to you next speaker, who is Mykola Gnatovsky. As it was told, he is professor of Taras Shevchenko National University of Kiev and advisor to the Minister of Foreign Affairs, but we can also congratulate him with new appointment, as far as I know, from July. Yes, professor is elected to the European Court of Human Rights from Ukraine. So our joint congratulations, and as it was indicated, your topic would be, for introductory remarks, of course, the issue of aggression from Ukrainian legal and political perspective, the call that emanated from Ukraine for the establishment of the tribunal, and the impact on the ongoing armed conflict. So please, the floor is yours.
Thank you very much, Professor Žalimas, and I'd like to start with thanking wholeheartedly the government of Lithuania and the Ministry of Justice in particular, the minister, the deputy minister, and to you, of course, Professor Žalimas, dear Dainius, for setting up this, for organizing this conference so brilliantly. And that is hugely helpful, not just for us to finally meet in person after many years and after so many conversations in video conferences, but just because this is the right moment, I think, to enhance the momentum that already exists for the creation of the tribunal, and these discussions should be hugely helpful. So thank you very much for this. I was very happy to listen to all the presentations and discussions this morning, because so many important points were made that completely laid out the scene so clearly that now I think we can speak specifically about the proposal to create the special tribunal. And let me continue a little bit at the point where Philippe has left it. Because, again, looking back several weeks ago, when the Russian aggression against Ukraine has turned into a fully fledged war, fully fledged invasion, I as somebody who has never worked for the state as such, and who stayed away from public service, I had to contact the foreign minister and basically to tell him, well, benefiting from our old friendship, that if there's anything, is anything that I can do to be helpful to Ukraine, I would be doing just that and nothing else. And he said one word: aggression. So what you need to do is to concentrate on the act of aggression and the crime of aggression. It should be recognized universally, and ways should be found to hold the Russian leadership and Russia as a state responsible for what it is doing. I started by contacting various associations of international law and various national societies and so on. And I saw that actually they didn't need to be prompted to very quickly issue powerful statements qualifying the things as they should, including not only the national societies or the ILA, but for example, l'Institut du droit international also published a very, very helpful resolution in this respect, and others. So it was obvious for the College of International Lawyers what was happening, and that the qualification is crystal clear. And indeed, as already mentioned during the morning session, there hasn't been a war of this scope in Europe since the Second World War, perhaps with the exception of the war surrounding the breakup of Yugoslavia. But again, this is a war of aggression, basically a war against territorial integrity and political independence, and in fact the very existence of a major European state by another major state. And this is something that was obvious that in legal terms. But now the question is, as the substantive law was there, as Philippe has just said, that there should be mechanisms around this. And that's why when Philippe published his piece in Financial Times, and also we got in touch, and he was also in touch with Minister Kuleba, who immediately understood the proposal, as he has international criminal law background himself, luckily. We started working on this, and I was so impressed by Philippe and those colleagues who have joined this enterprise, and I'm delighted to see here Dapo Akande and Alex Whiting and Arif Abraham and those who have worked with us, also Gordon Brown, who spoke earlier today. This has been a fantastic experience, and it was obvious that we are there to find ways to make sure that the accountability becomes real, that the accountability is there. So it is not a question what needs to be done, it's a question of how it needs to be done. Turning it slightly from a different angle, looking at it on a different angle, I would say that it's no longer viable to try and discuss why a mechanism cannot be created to hold those responsible for this war of aggression accountable for it. But it's a question of what do we do and how we ensure that this actually happens. And in fact, whilst the war is ongoing and the hostilities are progressing, we are seeing evidence of shocking war crimes against humanity. And there's unfortunately a very serious discussion now, even invoking the notion of genocide, which is unfortunately on the table somehow. And it is very present in the political statements made by world leaders. And this should by no means distract the attention from the original crime, for the crime from which it all flowed, as Philippe has mentioned, the crime of aggression. Also because there is institutional architecture for to prosecute atrocities. It is a very difficult task for sure, but the ICC has jurisdiction, and there's efforts at the national level by Ukraine, by a few other states, including Lithuania or Poland and a few other countries. So there would be also, use will be made of universal jurisdiction perhaps, and certainly it will be possible to find, hopefully, to find a way to ensure that the ICC and the national jurisdictions interact in a way that would be appropriate for the crimes of this level. But the crime of aggression, nevertheless, has to be addressed in the first place. Also because sometimes one is astonished about the discussions on the war crimes. It's very difficult to prove war crimes, in fact. The discussion whether the initial target was a lawful one or not can last forever. The discussions about whether the principle of proportionality was actually adhered to or not, whether precautionary measures were taken or not, and things like this, they can really drag for many years. And these are not things which are so clear, unlike the crime of aggression. In the paradigm of the crime of aggression, there isn't a single lawful act which is being committed, which is being carried out by the aggressor state, because the crime of aggression is a continuing crime. It's not just the decision to invade another country. It's also everything else that is being done in the implementation of this decision, in waging of this war. And that's why when now there's discourse that in fact these things are not so straightforward, and perhaps in many cases it's just the military objectives that are being targeted and so on, they become much less relevant for this particular topic, because the distinction between jus in bello and jus ad bellum issues should not be used here by those who have attacked the very basic foundations of international legal order to evade responsibility. So that's the gist of it. And then, of course, the proposal to set up a special tribunal, which is, I think, meeting with a lot of understanding everywhere, is just now about the ways how to implement it, whether it is done through a multilateral treaty, whether it is done through a treaty between Ukraine and an international organization, whether there's a collective effort by states who are ready to be more active at this stage, which can be endorsed and supported in various ways by other states and international organizations. There's plenty of things to do, plenty of ways to achieve the goal. But this discussion should not distract us from the need to address the issue as a matter of urgency. Luckily, if one can use this word in such a grave, in fact terrible context, it is not particularly complicated to investigate the crime of aggression. There are things there which need to be approached very carefully, but the very fact that already in the public domain we have at least 2 draft indictments for the crime of aggression against the top Russian leadership is very telling, because these are done by academics, by lawyers who never left their office to write them. But so it is something that is perfectly achievable. In the political context, and I will be wrapping up here, Dainius, in the political context, this is a highly important decision. And of course, one has to completely realize that even indicting a sitting head of state and other top officials of the state is not simply about the way of delivering justice. It is also a very important political decision. The political decision that shows that this kind of wars of aggression of this scope and with such goals as almost openly declared by the Russian leadership, again as discussed very profoundly this morning, they will not be tolerated, no matter what. In a way, this might be seen as somehow, by some, and I would understand that completely, as a point of no return. But do these circumstances not warrant such an approach? That's my question, and I think it's a rhetorical one. Thank you very much for your attention.
Thank you. Thank you very much, Mykola. And now we can continue on the law relating to aggression. namely also jurisdictional, to start with jurisdictional issues of a possible tribunal and how it can be derived for the tribunal, from which sources. And I am pleased to introduce to you Dapo Akande, who is representing Faculty of Public International Law of University of Oxford, and who is also a member of the UN International Law Commission from 2023. So please, the floor is yours.
Thank you very much. Thank you for the kind introduction. And like all the others, I also want to join in thanking the government of Lithuania, and in particular the Ministry of Justice and the Vice Minister for organizing this. I would like to spend the time that I have talking about the how. You know, we've talked about how might this tribunal be created, and we've mentioned various possibilities. And really what I'd like to do is to set out what the options are, and then to talk a little bit about why, or how rather, the choice of option might matter. So the first thing and the starting point is that we're talking about what we've all been describing as a special tribunal, a tribunal that has an international element. And so there you have, essentially, we're talking about a tribunal that finds, in some sense, a legal basis in international law. And by that I mean that it is created by agreement between Ukraine and either an international organization or between Ukraine and a number of states. Now, I say a tribunal that finds its legal basis in international law in that sense, but it's also important to note that we're also talking about a crime which occurred on the territory of Ukraine, and with respect to which Ukraine has jurisdiction, both under its own national law, but which international law confers jurisdiction on Ukraine. There's a territorial jurisdiction that is conferred on Ukraine by international law. So even though we're talking about a tribunal that will have an international basis in the sense that it is created by way of an agreement between Ukraine, a treaty basis between Ukraine and some other entity, be it state or an international organization, as with all other international criminal tribunals, really the legal basis for the exercise of jurisdiction by these tribunals is one which operates by delegation from national jurisdiction that these entities have to the international body. And that's true even of the International Criminal Court, that essentially what you have is states coming together to delegate a jurisdiction that they have to the International Criminal Court. So what are our options? So option one is to have a tribunal that's created by agreement between Ukraine and the United Nations. And there, of course, we have existing models. We have the model of the Special Court for Sierra Leone, where you had an agreement between Sierra Leone and the UN. In fact, the UN Secretary General entered into that agreement, but on a mandate from the General Assembly. And so in that sense, you don't need the Security Council. It could be the General Assembly mandating the Secretary General to enter into an agreement with the UN. So that's option one. Just to list the options and then to come back to them. Option two would be an agreement between Ukraine and a regional body. Could be the Council of Europe, could be the European Union. And there also we have precedents. So for example, the tribunal that Alex is a part of, the Kosovo Specialist Chambers, you have an agreement there between Kosovo and the EU. We've also had precedents in that regard, and I will return to this later on actually, outside of Europe. So we had the tribunal that prosecuted the former Chadian head of state, Hissène Habré, which was a tribunal with the support of the African Union. And so that was a tribunal that was established by agreement between Senegal and the African Union. And then the third option would be an option which is a tribunal that's created by agreement between states. And there, of course, you can imagine that it could be a large number of states, a small number of states, whatever it could be. And in one sense, that is, at least as far as legal basis is concerned, not dissimilar to the International Criminal Court. Of course, the International Criminal Court has 123 states parties, but they're all states. They're all states that have created it. And there are also other precedents. Again, on the African continent, African states recently agreed a few years ago, the Malabo Protocol, an agreement between the members of the African Union to confer criminal jurisdiction on the African Court of Justice and Human Rights. Again, it's just an agreement between states. So you could have the question is how many states, but as far as legal basis is concerned, it's between states. So those are the options, and the question really is which option is best and does it matter which way you go? And there, essentially, there are political issues that one might consider and there are legal issues that one might consider. So in terms of the political issues, I think the thing that tends to be at the top of people's minds are questions of legitimacy. You want a tribunal that has the greatest degree of political support. That's one consideration. But of course, to the extent that you support the idea of having a tribunal, the first thing, I guess, is you want a tribunal. And what I mean by that is there might be some possibility, there might be some of these options that are possible, and there might be others that are just not possible. So in terms of wanting an option that has the greatest degree of political support, one might say you look naturally at the UN General Assembly, because if you can get a wide degree of support, that confers legitimacy. But the question is, can you get it? The other question that arises in relation to these political issues, the issue of legitimacy, and there's been a lot of discussion about considerations of selectivity and considerations of, well, if you can't do it through the UN, is it worth doing at all? Because does this send the wrong message as to the delivery of international criminal justice? And there, just come back to the points that I've been making about the precedents. This will not be the first tribunal that would be created on a regional basis. So I've already given examples of tribunals where you have a regional organization that enters into an agreement with states. And also, and I think this is important, some of the questions that are being raised around selectivity, particularly in relation to Europe. So the argument is sometimes made, well, would this just be another example of attention being given to something that is happening in Europe? And is that the reason? And it's exactly for that reason that I mentioned the two African precedents earlier on. So the Habre tribe, the African Union has actually been very keen on regional international criminal justice. And that has been supported, not just in Africa, but elsewhere. And that was the reason for having the tribunal that prosecuted former President Habre. And that's the basis of the Malabo Protocol, not yet in force, but it's the basis for saying that there should be the possibility of exercising jurisdiction on an African basis. So I think the argument that this would just be something being done in Europe actually wouldn't be the first in doing this. There would actually be others. And the interesting thing is, the Malabo Protocol, established by the African Union for the African Court of Human Rights and Justice, it includes jurisdiction over the crime of aggression. It would actually be the first, not in force, but there is already jurisdiction on a regional, I mean, when I say already, there's a treaty that is adopted on a regional basis that provides for the crime of aggression in Africa. So I would reject the idea that this would be something that's just special for Europe because we already have other precedents. So those are political questions relating to the basis. The last thing that I will mention, and this is the issue of, does it matter as a matter of law which of these options you go down? Now, all these options I think are legally available. One issue that is often raised is, to what extent does it affect the question of immunities? So because aggression is a leadership crime, we are talking about the potential of prosecuting people who have immunities under international law. And here I focus just on immunity ratione personae. So the first thing to note in relation to immunities is that we're only talking about three positions that attract this immunity under international law. And this is not coextensive with those who are subject to the crime of aggression. So it's the head of state, head of government, and foreign minister, to the extent that they are in office. However, the question is, does it matter which of these options, if, to be able to deprive these individuals of immunity? That depends on the position that one takes on this question of immunity. So one view is to say that if it is an international tribunal, any international tribunal at all, then there will be no immunity ratione personae. And that's the position that was taken by the appeals chamber of the International Criminal Court in the Bashir case, the case against the then Sudanese president. Now, I hasten to say that not everybody shares that view. But if you take that view that the ICC appeals chamber took, then on any of these models, because it's an international tribunal, there would not be immunity. The second option with regard to immunity, a position that has been taken by some, is to say that in circumstances where you have a tribunal, and this Latin expression is often used, which represents the jus puniendi of the international community. In other words, it's sort of representing the ability of the international community to repress these crimes, then immunity would not exist. And there it might matter. It might matter whether or not you say the tribunal is one which is representing the international community. Again, that's not a view that is necessarily shared by all. And then the third thing that I would say on immunity, and this would be the last thing that I say, is that there's another view in relation to immunity, which would be to say that in circumstances where you have a state that is exercising, in effect, a right of self-help, something that is akin to countermeasures or something that you might derive from the right of self-defense in responding to an act of aggression, that in those circumstances there would not be immunity. And that would be the case whichever of these options you go for. So let me stop there.
Thank you very much. And now I think the most logical would be, because you mentioned a few times about the existing precedents for the creation of various international tribunals. So I'm pleased now then to give the floor namely on this topic to the next speaker, Arif Abraham, who is a barrister specializing in public international law, international criminal law, and human rights. He advises to parliamentarians, NGOs, and international organizations, drafted a number of various legal instruments, and he is also founder of Accountability Unit, that is an NGO specializing in conflict resolution and justice issues. So please, the floor is yours.
Thank you very much. I'd like to begin by thanking the Ministry of Justice of Lithuania, the Vice Minister, and also Professor Zalimas for the invitation to speak today. I'm really grateful to be here with this distinguished panel. I'd like to make really three short points. First is to really build on what Dap was saying in relation to the precedents and outlining the extent of the precedents for setting up a special tribunal. Second, exploring some of the best practices in relation to any agreement or statute that might be the basis for a special tribunal, particularly in light of some of the objections that have been raised by some commentators. And then third, consider the issue of practicality of getting an agreement signed between willing states. In relation to precedents, I have identified approximately 25 relevant agreements since the 1929 Kellogg-Briand Pact, which is often cited as the precedent for the prosecution of German and Japanese leaders for waging wars of aggression post-Second World War. 10 of those are particularly relevant. Some of them have been mentioned by my colleague Dapo. The first, of course, is the 1945 Charter, an agreement on the international military tribunals. There's the 1903 and 94 statutes on Rwanda and Yugoslavia. There's, of course, the 1998 Rome Statute, which was obviously amended in Kampala in 2010. In 2002, there was the agreement between the UN and Sierra Leone for the Special Court. 2003, agreement between UN and Cambodia on the extraordinary chambers. 2007 was the agreement between the UN and Lebanon on the special tribunal for that. 2012, an agreement between the African Union and Senegal on the extraordinary African chambers. 2014 to 16, the Kosovo specialist chambers. And then the most recent one was the draft statute for the tribunal on the downing of MH17. In addition to these, what I would call conventional precedents, there are also the recent trend in people's tribunals, which are, of course, have no formal authority or powers, but these are light-footed, highly versatile, and may provide lessons in cost-effectiveness and streamlining of the work that might be required. Now, whilst the majority of these precedents dealt with a range of international crimes, and perhaps only two substantively address the crime of aggression, they all helpfully point to possible means and methods of creating a special tribunal. And that brings me to my second point. What might be some key best practices in terms of agreements or statutes from the available precedents? Well, I think there are three perhaps critical points here. The first is independence is key, as is application of relevant international conventions and norms. An international tribunal consisting of a majority of international prosecutors and judges significantly helps in this respect and would circumvent some of the problems related to immunity, legitimacy, and suggestions of selective justice, as Dapo has outlined. And the Sierra Leone Special Tribunal, which tried Charles Taylor, might be a helpful reference point there. Now, that of course, is quite different from an internationalized tribunal, which is a hybridized chamber within the Ukrainian court system. Now, there are some pros and cons of having a hybridized chamber, but of course, there is still room for maneuver, even if a court was to be part of the Ukrainian court system. The second point is, we're all aware that costly, unwieldy, and lengthy tribunals and courts rarely endear the international community. Now, I would argue that a special tribunal on aggression is significantly different in nature, scale, and scope from the previous tribunals, such as, for instance, the Special Tribunal on Lebanon, which has come in for criticism for its cost, the length of time it's existed, and the fact that there were no perpetrators that were apprehended. The difference here is that there is also a significant possibility of a range of perpetrators being eventually apprehended in various circumstances which we could envisage. So I think here, a special tribunal in this respect may provide an opportunity for a very light-footed and bifurcated model, a staged approach in its creation with possibly an interim office, a preliminary prosecution team, and a part activation into an adjudicatory body with a small chamber if and only if alleged perpetrators are apprehended. And I understand my colleague Alex will address this point. This possibility, I think, allows us to worry a little bit less about the resources that may be diverted, as has been argued, from elsewhere, and that can be significantly mitigated. The third point here is that in respect of any possible special tribunal, cooperation, coordination, and co-investigation is critical, both in amassing the evidence and in investigating, apprehending, and prosecuting the alleged perpetrators. This is no doubt linked to having a credible and authoritative international tribunal with wide support, but also having significant powers either on its own initiative or derived, as Dapo has suggested, from national jurisdictions. This brings me to my third and final point. With whom exactly might Ukraine strike an agreement for a special tribunal? Dapo very helpfully has covered most of the options here, and I'd just add to say that, of course, that a special tribunal can be an agreement between the UN and Ukraine on recommendation, critically from the UN General Assembly. Now, that would provide significant legitimacy. The two perhaps relevant precedents here are a hybridized chamber within the Ukrainian court system, and the precedent for that would be the extraordinary chambers in the courts of Cambodia. And critically here, that was a body that was created on recommendation by the UN General Assembly. The alternative is a freestanding hybrid tribunal. That would be like the Special Court for Sierra Leone, and I understand, I might be mistaken, Dapo would correct me, that that was actually set up by the UN Security Council, but not under Chapter 7. So again, it's another precedent that doesn't rely on a Chapter 7 authorization. A more realistic option, politically perhaps, is an agreement between the Ukraine and the EU, following, of course, the Kosovo precedent, and given that a joint investigative team under the EU auspices has already been set up, which ostensibly covers the crime of aggression, this would appear to be a possible natural progression. And an alternative, and increasingly a possible one, following loosely actually the African Union and Senegal precedent, would be a regional tribunal where an agreement could be formed between Ukraine and members of the Council of Europe. The PACE, the Parliamentary Assembly vote last week approving the creation of such a tribunal, obviously significantly augments this possibility. Perhaps the only critical shortcoming here is that it might require unanimity in order to create a special tribunal. And of course, we might have opposition in the form of two countries in particular, which would be Hungary and Serbia. The two alternatives here, as Dapo has suggested, is simply an agreement between an ad hoc group of states. That is a realistic possibility, including one that can be struck immediately with the possibility of future endorsement by others. And then perhaps the most unrealistic possibility, but it is foreseeable, is that an amendment to the Rome Statute is possible in 2025, although this is highly unlikely. My final point, I guess, is to say that we know that agreement with international organizations take time. Now, the very first step that could be already taken in respect of the work of a special tribunal is to actually begin in earnest with a coalition of the willing through an interim or preparatory office, as I understand Alex might discuss. And the sooner that work begins, the more likely the creation of a special tribunal becomes a matter, I believe, of inevitability as opposed to one of political expediency. Thank you very much.
Thank you. Thank you. Thank you very much. And let us continue on the options and why the special tribunal can be the best option. What is its importance for the development of international criminal law, and especially relationship, because we need also to define the jurisdiction with the crime of aggression as defined by the Rome Statute of International Criminal Court. And I am pleased also to introduce you to one more speaker who is online, Carrie McDougall. She is a senior lecturer at the University of Melbourne and former legal advisor to the Australian government, the author of the book The Crime of Aggression under the Rome Statute of the International Criminal Court. And she also represented Australia in the Assembly of States Parties of the International Criminal Court. So, Carrie, please, the floor is yours.
Well, thank you very much. Let me begin by publicly expressing my solidarity with our Ukrainian colleagues, as well as my thanks to our Lithuanian hosts for the invitation to address this very important subject. Ministers, other distinguished participants, as I've written and spoken about elsewhere, I firmly believe that the only viable option for prosecuting the crimes of aggression committed on the territory of Ukraine is to establish a special international tribunal. I want to focus the very limited time I have explaining why, in my view, it's absolutely critical that the tribunal utilise the Rome Statute definition of the crime. Now, let's address the elephant in the room. The Rome Statute definition is not perfect. I devote many thousands of words to critiquing it in my book, but this is not a reason to abandon or tinker with it now. We should accept that this definition was the hard-won result of almost 65 years of negotiations and now represents agreed international law. I also think it's important to acknowledge that in order to secure the support of those states that are generally the greatest champions of international criminal justice, we'll need to ensure that the tribunal complements the ICC and is in no way seen as undermining that court. This means that the jurisdiction of the tribunal needs to be limited to crimes of aggression committed in Ukraine so as not to undermine the ongoing ICC investigation into other serious international crimes, and that we should make provision for cooperation between the tribunal and the ICC in relation to matters such as the sharing of evidence, but also that the definition of the crime must conform with the Rome Statute. Adoption of the Rome Statute definition will help ensure the tribunal's legitimacy by avoiding any suggestion that a crime has been tailor-made for the tribunal, and it will avoid any potential fragmentation of international criminal law. Now, while I've suggested that the Rome Statute definition isn't perfect, I would underline that I don't think that imperfections are something that will represent an impediment to the successful prosecution of crimes of aggression committed in Ukraine. Many of the criticisms that the Rome Statute definition attracts relate to ambiguity associated with the definition of the state act element of the crime, the act of aggression, so that its periphery is unclear. But these ambiguities will simply not come into play because Russia and Belarus's invasion of Ukraine represent a textbook example of the state act element of the crime, as does the 2014 annexation of Crimea, squarely meeting the agreed core definition of the crime. The definition of the crime of aggression under the Rome Statute restricts potential perpetrators to leaders. In technical terms, prosecution requires proof beyond a reasonable doubt of the planning, preparation, initiation, or execution by a person in a position effectively to exercise control over or to direct the political or military action of a state, of that state act of aggression. The definition very clearly captures persons of interest, such as Presidents Putin and Lukashenko. It captures influential members of their inner decision-making circles in relation to political and military matters, persons that might include, for example, Russian Foreign Minister Lavrov. In my assessment, it doesn't capture the yes men surrounding President Putin who have had no actual ability to influence the decision of whether or not Russia used military force, or the generals who are implementing the decision to wage an act of aggression. Now, I would emphasise that in my view, determining exactly who is captured by the definition is likely to rely on the provision of intelligence information. And for that reason, I do recommend that the Tribunal statute include provisions on classified information in similar terms to the Rome Statute. I know our chair is interested in views on whether the definition could extend to members of the Russian Constitutional Court who upheld the legality of Russia's annexation of Crimea. And I'd have to say that in my view, such persons are excluded by the definition because they can't be said to have had a decisive say over Russia's political or military action. The last point I want to make is that commentators have in the past suggested that a broader range of perpetrators could be captured under customary international law on the basis of the Nuremberg and Tokyo precedents. And you might think that there are good reasons to adopt a broader definition of individual perpetrators in the current context. This argument really rests on the idea of a perpetrator being able to shape or influence, as distinct from direct or control, state policy, a test that was articulated in the Farben case. However, I think it's really important to note that the balance of post-war case law, including the Nuremberg and Tokyo judgments, are all inconsistent, such that it's very difficult to identify any sort of agreed rule about who could be prosecuted. Even accepting that a broader range of perpetrators were prosecuted in Nuremberg and Tokyo than would be possible under the Rome Statute definition, I think there's real merit in the Rome Statute's approach. The crime of aggression is all about punishing those responsible for deciding to use illegal interstate armed force and deterring future acts. These goals will be best met by maintaining aggression's status as a special category of crime with a focus on genuine leaders. This will ensure that those who were ultimately responsible for the decision to invade Ukraine cannot shift blame to others. It will also maximise the potential for a prosecution to give other leaders pause for thought about future uses of unlawful armed force. Thank you very much.
Thank you, thank you very much. And I would like to continue also with a more detailed explanation on significance of a jurisdiction of possible the tribunal. I am pleased to pass the floor to Eka Tkehelashvili, the head of the USAID flagship anti-corruption program in Ukraine, president of the Georgian Institute of Strategic Studies, and as well as the former Minister of Foreign Affairs and Vice Prime Minister of Georgia, as well as famous international lawyer, and who also specializes in public international law and international criminal law. Her topic is namely regional political and legal implications of the tribunal, and as well as including ratione temporis issues, because actually we are a lot discussing how far should go the jurisdiction of the tribunal, because we all understood that Ukraine is not the only direct victim of the Russian aggression, but it was some prehistory. And please, Eka, the floor is yours.
Thank you very much. I'll echo all of the participants of the panel to thank Lithuania as a country for everything they did for Ukraine, but then specifically now here in the Ministry of Justice, Vice Minister of Justice, for convening us today. And as much as Philip mentioned it as well, just recalling back how this all started in terms of idea and then first steps, thinking of making impossible possible. And here we are already talking about the real stuff, and when it comes to the real stuff, not just the legalities of that, but then how that could be accompanied with the political steps when it comes to decision making that could come into force in a short period of time, I would hope, with all of the efforts that we are putting together in this direction. We have very limited time, so that I'll concentrate perhaps on issues that I've picked up during the conversation on the panel, and then perhaps add to that. When we talk about a creation of the special tribunal, I think part of what needs to be understood by those who are well-intended naysayers so far, who say that whether or not creation of the tribunal will help or not ending of the war, let's say, if there's an inevitability of accountability for the higher-ups in the political spectrum in Russia, why would they even consider any peaceful talks, right? In this case, or whether or not if the tribunal is a paper tiger, does it make sense at all? Maybe it will bring more frustration to Ukrainian people that there will be tribunals, something will be happening, a lot of time will pass, but nothing will end up in the concrete result, so to say, impact that it could deliver. And then I would suggest the following. When it comes to the tribunal and importance of that for the second argument that I've just mentioned, for decades already in the region that I represent, colleagues from Ukraine represent, we have suffered from Russian, not only oppression, but military aggression a number of times. My own country actually in 2008 was the first country where Russia used force openly against another sovereign country without any repercussion as a result of that, and enjoyed the plausible deniability of what Russia actually did. What Russia did in 2008 was plain aggression against another sovereign country. which was not even labeled as such for different reasons, but then Russia maintained that plausible deniability. Then, because of that, partially, not only, but that was the first time Russia tested the red line, so to say, successfully in Russians' view, and then what followed was annexation of Crimea, and then Donbas and Luhansk in terms of the de facto occupation of the territories, and then prolongation of the conflict. Again, very little as a repercussion for Russia. At least legality of annexation, as an annexation was recognized as such, and an acceptability of that, as much as territorial integrity of Georgia as well previously. But Russia basically paid very little price for that. So my message in this regard is that even the fact of credible tribunal delivering judgments on aggression vis-a-vis individuals that are culprits of that crime will be already sufficient, not fully, but satisfaction for so many of us in the region that Russia will cease to have any plausible deniability of what Russia is doing. And when we look about whether or not it is apparent that Russia is aggressing Ukraine now, we still live in our bubble of the Western world in one way or the other. Look at the voting of the UN General Assembly, subsequent second one, and then if anybody follows the media discourse in other parts of the world, it's not that straightforward. So when it comes to straightforward understanding that this is what it is, and this is aggression, plain, straightforward, and then even if that is established in a credible way, and even if culprits will not be apprehended anytime soon, this is still very important as a deliverable of that very important tribunal. Because that will have its own impact, I'm sure, globally, on the countries that still might have that illusion, if not political expediency for some now, to have this, doubtful understanding of what is Russia actually doing. Now, that's one very important factor. Politically speaking as well, it's very hard to imagine that if there will be judgments on Putin and then, his comrades or whatever they are called, how they will be active in a political scene, because there is a huge political component into that. It will be very hard to invite anybody in G20 meetings or anywhere else against whom you will have credible judgments that they are aggressors. So even if they will not be apprehended, put in prison or anything else, it is already punishment, and it's already justice that is served with that. Then the question related to financial aspects that the Minister Maluska raised today, hugely important. There is a lot of coordination right now in legal world, so to say, of the programs and then partners that are helping Ukraine now with war effort, and then legal field is a war effort in its own way as well, to see how tracing of Russian assets, seizure of Russian assets could happen. And then the sovereign immunity that has been mentioned as well. I mean, we don't have answers now, but this is a question to keep in mind. What is the relevance of all of that in that direction as well? Because Ukraine needs to be put back into life, not only just as a matter of rebuilding Ukraine. Ukraine needs to be reconstructed in the way that it will be a shining example how much better, even more developed it will be, so that everybody in Russia who now supports the war effort sees where they are back to Soviet Union life, and then how international community can pick up support and resilience, and then, rebuild Ukraine in the way that it's everything contrary to what they hoped that they could achieve in this war effort. When it comes to the peace talks, I think this is important to realize as well that Russia has no intention to negotiate anything right now. Russia, and especially Putin, understands the language of war. And then if we take an analogy of the Second World War in that terms, and I'm not a military expert in this regard, but I have unfortunately quite a bit of expertise of dealing with Russians in my own life, it's the victory of Ukraine militarily that can define what will happen, not only for Ukraine and Russia, but for all of us sitting in this room, and then globally as well. What is happening in Ukraine is shaping the future of our children, grandchildren, and then for decades to come. So in this regard, nothing that could relate to the establishment of the tribunal could derelay any peaceful talks as of now. And if we take an analogy of what Philip mentioned of 1942 and then onwards, actually it could even help, because it could create incentive for some in the establishment in Russia to negotiate agreement for them, for being supportive of the defeat of Russia, if we put it in this way. So we can think of it as an enabler of the solution rather than an impediment in this regard. If we talk about sort of ratione temporis, I wanted more not to dwell too much, not to complicate the possibility of creation of the tribunal with what happened in my own country and then before, but rather to plea very strongly that the aggression did not begin on 24th of February. So if we speak about the beginning of the jurisdiction of the tribunal, it starts with the annexation of Crimea, clearly to me. Because even with the restrictions of the definition of the Rome Statute currently, annexation is there. And if we allow to have plausible deniability again what happened in Crimea, as if there was real referendum, and if the green men, we are not actually a Russian military, so we are not doing justice to what happened. So beginning of the jurisdiction of the tribunal is starting clearly from the annexation of Crimea, and then that will be one of the biggest, strongest element of delivering justice to what Russia did to Ukraine, but we will feel vindicated as being Georgians and everybody else as well, who are still suffering from the occupation of Russia, by the way, in my own country, and dangerous that others might feel, like in Moldova and elsewhere as well. And I would believe that even friends from Syria that we have contacts with will feel vindicated partially as well if justice is served in this case. Everybody who suffered from Russia will have that sense of vindication in many ways. And then ultimately, when it comes to the ratione personae, so to say, in this case, I would slightly disagree with limited understanding of who could fall into it, because Russia is a dictatorship, right? So that if you go too much into who can actually really influence to the decisive degree of decision-making processes, it will be very hard to establish who, apart from Putin, but I don't believe that it's a one-man show, but still could be culprits in it. We need to respect the constitution of Russia in this case. So who are the decision-making bodies? What is the role of the parliament? What is the role of the court? Who are enablers in the decision-making process that by definition have decisive role that they need to play? We cannot reward dictatorships by limiting the scope of who are responsible for aggression in this case. And I feel very, 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 very strong at my side on that, but I hope that there will be sort of a more broad definition of who are enablers and participants of aggression in this case, rather than very limited circle who could give a good escape road for those who are actually very much culprits of aggression against Ukraine now. Thank you.
Thank you. Thank you very much, Eka. Indeed, I fully agree with you that the classical principle of a division of powers is not applicable to Russia. Actually, I remember as the head of the Constitutional Court of the Russian Federation, he's one of the ideologists of this Russismo, Russian world, and in his books openly justified the annexation of Crimea and the decisions made by the threat of terrorism from Crimean Tatars and many other propagandic cliché. But of course, in future, it would be nice to have more detailed discussion on actually who is subject to the jurisdiction of a future tribunal, but now I would like to continue with the issues also of the jurisdiction, ratione temporis, maybe ratione personae as well a little bit, and what role can be played by the future tribunal for the victims of war. And I'm pleased to pass the floor to the next speaker, who is Oksana Senatorova, Director of the Research Center of Transitional Justice at Yaroslav Mudry National Law University, as well as founder and director of the NGO Center for International Humanitarian Law and Transitional Justice, and an expert of the International Council at Ukraine's Office of Prosecutor General. So please, the floor is yours.
Thank you very much. Madam Minister, Madam Deputy Minister, distinguished colleagues and friends, it's my honor to be here at this conference, and I also want to express my gratitude for people of Lithuania for opening your arms for Ukrainian people, for Ukrainians, and for standing with us in this struggle against Russian aggression for your solidarity with us. In my very brief presentation, I would like to stress the issue of a possible mission of the special tribunal, the role that it could play for the victims of this war. During the next discussion, I will be delighted to say a few words concerning the options and challenges of the tribunal's ratione personae and ratione temporis jurisdiction, and some aspects of the possible composition of the court. I propose to begin by raising the question of how the international community and the Ukrainian people envisage this tribunal and its aims. As you know, the ICC has launched an investigation concerning war crimes, crimes against humanity, and possibly genocide. Ukraine and other countries will prosecute these crimes in the national jurisdictions of both Ukraine and other countries based on the universal principle. They are hopeful on the ECHR as well, but will the victims of this war be satisfied when the ICC brings a few people to justice after a rather considerable period? How many people will be directly compensated through international and domestic trials? We all know the answer to these questions. Let me remind you that victims of the aggressive war are not only those who have suffered war crimes and other international crimes, though there are thousands of them in Ukraine. Millions of Ukrainians experienced so-called self-evident consequences of armed conflicts, such as cannonades, shelling, the necessity to become refugees and IDPs, and the legitimate, according to the IHL, attacks that caused loss of life, legitimate damage to civilian objects and infrastructure. They will not be considered victims of serious violations of human rights in the IHL, and thus could not hope for reparations in ICC or national jurisdictions. But they are victims of aggression, of the crime of aggression, those who have never been directly compensated after the previous world wars, as far as there was only state-to-state reparations proceedings. There are only some precedents of ad hoc mechanisms of direct restitutions to the victims of aggression. I mean, the United Nations Compensation Commission established to determine and dispense reparations after Iraq's invasion of Kuwait in 1990, the Ethiopia-Eritrea Commission criticized, frankly speaking, but take into consideration that those mechanisms were created after the end of hostilities, and the first one I mentioned was created by the United Nations Security Council decision. Nowadays, the ICC has a mechanism of reparations for the crime of aggression. Still, it cannot be activated because of the absence of the ratione materia jurisdiction in our case. Actually, it was never activated for the crime of aggression, and I'm not sure it will be triggered in the near future. So, this tribunal will present, can make an input for realization of the idea of reparations to the victims of aggression. As for the ECHR, European Court of Human Rights, it has only limited opportunity to compensate the negative results of Russian aggression. It is possibly only for the gross violations of human rights, such as the crimes against humanity, but not for legitimate attacks because of IHL lex specialis. The only way to bring justice to the millions of Ukrainians whose lives have been ruined in this war is to prescribe a special mechanism for reparations to the victims inside the tribunal. In my view, the victim-centered approach should become one of the main goals of this tribunal. Another important goal is to provide the credible deterrence and criminalization of the crime, not criminalization, deterrence of the crime of aggression. Over the past decades of multiple Russian Federation occupations of the territories of the neighboring countries, this violation of Jus Cogens rules was tolerated by the international community. I echo to your words in this regard. Hobbled United Nations Security Council, narrow jurisdictions of ICJ and ICC, and the other big countries frustrating precedents of the absence of liability for illegal use of force. they ensured the Russian leaders would not be held accountable for their acts of aggression. And as Benjamin Ferencz said, that aggression is a breeding ground for another international crimes. Thus, prosecuting aggression, we prevent them also for future generations. I don't know whether I have time for opening the challenges, but I would like to stress only several of them, several questions. The modes of realization of this mechanism is also the issue for discussion. We can use the model of ICC, overcoming its imperfections and gaps, taking into account the experience of ad hoc mechanisms and national mechanisms of reparation during transitional justice proceedings. The open issue, the open question is the circle of victims of aggression here. Whether it will be only individuals or only the legal entities, communities, whether they are only Ukrainian citizens or representatives of other countries as well. Should combatants be included, because the use in Bela doesn't work here, or only protected by IHL persons? Should Russian citizens who suffer because of their fight against this aggression be included? Lots of questions to answer. What source of financing should be chosen for the reparative mechanism? All of us discussing today this issue. Should it be only the assets of criminals, arrested property of the Russian Federation? As you know, the crime of aggression is an act of a state. Donations, maybe from international organizations, democratic states, and private funds. Everything mentioned could be taken into account. To my mind, the more sources, the better. But of course, it is an open field for discussion. Touching the jurisdictional issues, I should kindly remind you that there are several challenges concerning the Republic of Belarus and its de facto leader. Of course, Belarus violated at least Article 3F of the resolution 3314, the definition of aggression. But we must take into consideration that the EU and other countries consider Lukashenko legitimate, which may mean he doesn't possess the immunity ratio persona. Of course, it is not about the prosecuting him in domestic jurisdiction, but maybe it can play the role in the international tribunal. We also have to discuss the opinion of Belarusian international lawyers who consider that Belarus was occupied after these elections, illegal elections, and maybe it brings some other angles to this discussion. And of course, I support ECHA that the beginning of the temporal jurisdiction starts in the late February of 2014, at least the 20th of the February, with the invasion of Russian Federation to Crimea. And of course, we have to consider the qualification of this conflict. It is definitely the international armed conflict, and I want to pay attention that there are no separate conflicts. The Crimean conflict, the Donbass conflicts, it is only one conflict which started with the invasion and then continued in proxy character in Donbass region. And of course, it was continued with this hot phase of hostilities after the 24th of February. The last one, but not the least, the judges, the composition of this court. I suppose that they should not be the representatives of states, if we are talking about the multilateral treaty, for example, but they have to act in their personal capacity. And I, of course, want to pay attention and to discuss the opportunity to include judges from the Russian Federation and Belarus, those who are impartial, non-governmental experts representing the democratic parts of the peoples of those countries. I know some of them. I realize that this proposition would launch a whole discussion, but we should recognize that the value it brings to the principle of impartiality and impartiality of this impartial role of this tribunal. Thank you for your attention.
Thank you, Oksana, very much. And now let's go to the more detailed issues such as investigation and prosecution, and I don't know, what is required to prove the crime of aggression, and what is the of the investigation. I am pleased to pass the floor to Alex Witting, who worked at 3 different international tribunals and currently is the Deputy Prosecutor of the Kosovo Specialist Prosecutor's Office in The Hague, and also visiting Professor of Practice at Harvard Law School. So please, the floor is yours.
Thank you, and I want to join in the others in thanking the organizers, the Ministry of Justice of Lithuania, the Justice Hub, and of course all the participants, all of you who are here today, who are committed to thinking seriously about accountability. I will speak very much from the perspective of a prosecutor. As you heard, I have worked in 3 different international tribunals in The Hague. I'm now at the Kosovo Tribunal. I was also a federal prosecutor in the United States. And I'll draw on that experience to make a few remarks about the idea here that we're talking about. And I want to talk about 3 points. The first is, what are the challenges facing prosecutors? The second is, what would a court look like? And the third is next steps. So with respect to challenges facing prosecutors, you've heard from a number of previous speakers what the elements of the crime are, and it's that there was an act of aggression, manifest violation of the UN Charter, that the perpetrator played a principal role in it, in initiating, planning, executing the act of aggression, and then fourth, finally, that the perpetrator had effective control over military or political acts of the state. And I will echo what Gordon Brown said this morning and was echoed by Philippe Sands this afternoon, that the path, with those elements in mind and the evidence that is available to everybody now and what we can see with our own eyes, the path to an indictment of Mr. Putin is pretty straightforward. And it is particularly straightforward in comparison to imagining a future indictment of Mr. Putin and the leadership for war crimes, crimes against humanity that are being committed in Ukraine. There are intensive investigations going on right now by the excellent investigators at the International Criminal Court and of course investigators in Ukraine to try to show that responsibility. But that is, I can tell you from experience, that is hard, painstaking, long work. It's one thing to sit here and think, well, of course they're responsible. I can tell you it's something completely different to prove that in a courtroom with real evidence beyond a reasonable doubt, which is the criminal law standard. The evidence required to prove the leaders responsible for those crimes usually is derived on pattern, establishing a pattern of crimes, and then also developing linkage evidence through witnesses, communications. That's hard evidence to get and to prove. And the investigation, I would expect, would take some time, be painstaking, and then the proof in court would be also long and painstaking. In comparison, an aggression case against Mr. Putin would be relatively straightforward and more solidly based in terms of evidence. The leadership case for war crimes and crimes against humanity will not only be difficult, but will always be contentious. I think the principal challenge for the prosecutors on an aggression case will be not Mr. Putin, but who else? The people around, and you just saw that. That was just nicely illustrated between Kerry and Eka, talking about, well, how do you make the decision about who else is going to be in that circle? And I think that would be the hard work that the prosecutors would face, is developing the evidence, because it's not enough who has de jure power. You'd have to prove who had actual power to affect the decision. The second point I wanted to talk about is what would this court look like? And here I really want to very directly address the issue about resources, because that is floating around. And just to give you the punchline, I don't think that the concern about resources should be a serious impediment to constructing this tribunal. I think that given the very specific task that this tribunal would face and the kind of evidence that is available, it could be a relatively and objectively small court. I think that the office of the prosecutor could be not much bigger than this panel, honestly. Seriously, 10 to 20 people, really 10 to 20 people in the office of the prosecutor, if you got the right people. If you had prosecutors, you'd collect some prosecutors, investigators, analysts, some cooperation advisors, but a core group of 10 to 20 people in the prosecutor's office, which is much smaller than any other international prosecutor's office that exists. And then on the judicial side, you would follow the model of the Kosovo court and have a roster of judges, but only bring in judges and pay them when they had work to do. So you would bring in a judge to confirm the indictment, but you'd only bring in other judges if there were people who were actually arrested. And so I think that this could be done, honestly, for very little money. We were talking about whether that would be the equivalent of 1 or 2 tanks to pay for the tribunal. But really, this is inexpensive justice. And then the third point I wanted to touch on is what are the next steps from here? And Arif anticipated this point. We heard this morning from the Ukrainian Minister of Foreign Affairs, Mr. Kuleba. He said at the end of his remarks, he demanded concrete and swift action. Those were his words, concrete and swift action. And I'm encouraged by this, by how much has happened so already on this idea and what's happening here today, that this idea will be achieved. But a concrete and swift action could be to set up an interim prosecutor's office to begin already to collect evidence. And I think there would be 3 advantages to doing that, 3 important reasons to doing that. The first would be that there is a certain amount of startup time that is required for setting up a prosecutor's office, finding the right people, having a place set up, and protocols and so forth. And that time could already be invested now if you set up an interim office. Secondly, I think that taking concrete steps would help make this a reality. If this started, we're here talking and there are lots of ideas and there are lots of challenges, and the main challenge is how to translate that into reality. Taking actual steps to have people start working on this would help accomplish that. And then the third thing is that, of course, it's always an advantage for prosecutors, and again, I'm thinking as a prosecutor, always an advantage for prosecutors to get in early and to start collecting the information, preserving it. I don't think it's going anywhere, but that work should start right away. So if we want to heed the words of the minister, Mr. Kuleba, concrete and swift action, that's what I would do. Thank you.
Thank you. Thank you very much. And now the last speaker in our panel, Anton Kornevich, an associate professor of international law in the Institute of International Relations of Taras Shevchenko National University of Kiev, also an agent of Ukraine before the International Court of Justice in the allegations of genocide case. Before that, he also served as permanent representative of the President of Ukraine in the Autonomous Republic of Crimea, and his field of expertise involve public international law, international humanitarian law, and international criminal law. So please, the floor is yours. You're on the impact and expectations of Ukraine from this future tribunal. And before giving you the floor, I would like to say that I abuse a little bit my powers of moderator. Let's extend the session up to 20 minutes.
Thank you so much, Professor. Dear colleagues, first of all, of course, I would like to start with huge thank you to the whole Republic of Lithuania for all the support we see for all these 8 years of Russian aggression, and of course for the government and the Ministry of Justice and for the Law and Democracy Center Justice Hub for holding this conference. This is the first big conference dealing with specific issue of this special tribunal on the crime of aggression against Ukraine, and I'm sure that this is an important event, important moment, which will bring us closer to our final goal, to the establishment of the tribunal and its prosperous and effective work. Of course, it's a big pleasure, and it's very important and to be here present with such a distinguished panelists and to share some thoughts and ideas as a Ukrainian lawyer concerning Ukrainian perspectives. Well, for Ukrainian lawyers who work now in the field of international criminal law, international humanitarian law, in general international law, I think that this is some kind of a duty, and this is more than a job. It's actually not a job of coming to the office and working there from 8 till 6 or whatever. This is something what you need to do. You need to do whatever you can in order to make all this happen. And I wanted to start with the issue of importance of the establishment of the tribunal for Ukrainian people. And I want to mention that it is very important for us all to realize that for Ukrainians, for our nation, for our people, it is very important to have justice and to bring perpetrators of this war of aggression to responsibility. It is not only about the cells in the prison, but this is about indictments, this is about arrest warrants. And Ukrainians now really much feel that we are making history. Like our armed forces, we are beating the Russian armed forces, I mean, who pretend to be strongest, powerful, but I mean, in many places you see the story, how the story goes. So this is history making, and of course our main heroes are our Ukrainian soldiers and officers, our armed forces. They are making an unbelievable job. But I think that understanding these historical moments for Ukrainian people, it is very important that the justice also happens. And this analogy with Nuremberg and Tokyo, I mean, of course, pay particular attention to Yugoslavia, of course, in the 1990s, but this idea that the biggest war in Europe happened in 1945, and after that, this is the biggest war of aggression, and the prompt and appropriate legal answers were the establishment of Nuremberg and Tokyo Tribunal, and the establishment of the special tribunal for the crime of aggression against Ukraine is really seen by our nation, by our people, as a proper and appropriate legal result. So that is why I'm sure that Ukrainian civil society, Ukrainian experts, ordinary citizens will really very much be in favor and of the establishment of the special tribunal. It is also understood throughout Ukrainian legal community and in civil society that for bringing perpetrators of the crime of aggression to justice, we need the establishment of the special tribunal. Because everybody understands that with due respect to the ICC shall do its job with war crimes, crimes of aggression, alleged crime of genocide. With all due respect to national investigations and national courts proceedings, they are not operational, yes, because ICC doesn't have jurisdiction over this crime in this particular case, and Ukrainian national courts will have to deal with immunities, with personal immunities of the highest political ranks of the Russian Federation. So, of course, this is also why the special tribunal is so important for us now. It is also, I think, that this panel is a brilliant example why this tribunal is important for international legal society, for intellectuals, for international lawyers. And I think that all these brilliant colleagues have gathered together a lot of things right now, and we have a relevant background, worked on this expert level to move further to the governmental track. I think that now the moment has come with these resolutions of the Parliamentary Assembly of the Council of Europe, with this Vilnius conference, with these esteemed colleagues participating in it, to move further to the governmental track. And I'm sure that these governmental official consultations will start rather soon. It is also important to realize that the establishment of the tribunal is supported by the Ukrainian state authorities, in particular by Mr. President Volodymyr Zelensky. He publicly supports everything which deals with legal responsibility of the perpetrators of all the crimes which were committed and which are still committed by the Russians in Ukraine, and he himself talked about the tribunal concerning the crime of aggression, and the management of the office of the president also publicly on press briefings for Ukrainian media in interviews talk about the importance of the establishment of these tribunals. You heard today the brilliant intervention by Mr. Dmytro Kuleba, Minister of Foreign Affairs of Ukraine, who also is a big proponent of the establishment of the tribunal, and I'm sure that the ministry will be very effective in doing the job, in making this official governmental track happen. Concerning the civil society support in Ukraine, we also cooperate with different Ukrainian human rights NGOs, activists who work throughout all these 8 years in relation to gathering the evidence of alleged war crimes, crimes against humanity, now the alleged crime of genocide. And we may be pretty much sure that the idea of the establishment of the special tribunal and understanding that there are really no alternatives to it, if we really want to talk about legal responsibility, individual criminal responsibility of perpetrators for commission of the crime of aggression, so that really there are no real alternatives to this. And maybe to sum up, to wrap up, concerning the expectations of Ukraine from the tribunal, of course, the main expectation is to bring individuals to responsibility for committing the crime of aggression against Ukraine. And again, I will echo the thing which I just said, that responsibility is not only about the prison. This is about indictment, this is about arrest warrant, this is about non-participating in normal political life of the world, of the region, of the country. So this is really very much important. I think that for Ukraine and for Ukrainian people now, it is very important that this aggression against our state, it cannot be left without the proper legal response. Because Ukrainians believe in international law, I'm sure of that, and they understand that international law is about protection of those whose rights and interests are being violated, in our case by the Russian Federation. So I'm sure that this understanding that this war of aggression should not be left without the reaction. The world cannot be silent. This is very important. Because whenever, we have even such a poem in Ukraine by one of our poets, it has a line there, like, when Ukraine was raped by Russia, the Europe was silent. It's not about our time, it's about the beginning of the 20th century, but Europe was silent. And Europe and the world should not be silent anymore. And of course, concerning the ratione temporis, as I served as the President's representative for Crimea for almost 3 years, of course, for myself, it is obvious that the crime of aggression, ratione temporis jurisdiction, shall start in the end of February 2014. Again, this is important for the nation, and this is something what our people understand in general, and it doesn't need to be clarified to them. And one last point is that we see the very beautiful sunflowers here on these tables. Sunflower is a symbol, unfortunately, of a big tragedy of the Battle of Ilovaisk in the end of August 2014, when Ukrainian armed forces got a lot of casualties. It was one of the biggest tragedies before 24th of February 2022. the sunflowers in the field near the city of Ilovaisk in Donetsk Oblast, Donetsk region. But after 24th of February, we have Bucha, we have Irpin, we have Hostomel, we have Mariupol. We don't know what is happening there. And we need to do all our best in order to get these perpetrators responsible for all these crimes and for the crime which gave rise to all the other crimes, the crime of aggression. I thank you.
Thank you, Anton. Thank you very much. And now it's time for questions and answers, but again, I'm a little bit abusing, because I can mention at least 3 questions I usually receive from the audience and from public here in Lithuania regarding the special tribunal. First of all, of course, it's the question which we haven't touched here, but maybe a few words about that, the possibility of trying in absentia. Because who knows, maybe, no, it's also possible way of development. Next 2 questions, they are, of course, much broader, but again, it's possible to say a few words about that. Regarding ratione temporis, really, I feel that the people expect that the special tribunal would somehow, I don't know, involve previous acts of aggression, even before the Crimean annexation. I mean, against Georgia, maybe, I don't know, Moldova, who knows, but anyway, at least I feel such expectations related with, because it's the general feeling of justice and the general need to condemn the dictatorship in Russia. And the last, because I'm even obliged to ask you, because Justice Hub was established, first of all, as NGO devoted to Belarus. What about Belarus, really? Not about its involvement in the aggression, but how do you think maybe the special tribunal can serve as the precedent for the future tribunal, also for the crimes against humanity, because it's my firm belief that this is crime against humanity, also committed by the Belarus dictator against his own people, or it's also somehow possible to involve. Of course, there are too much expectations, but anyway, in a few words, maybe starting with Felipe.
Thank you. Gosh, what an incredible privilege listening to this group. I have learned and thought a lot. Very briefly, in absentia, this is a very culturally specific issue, and although I am a dual French-British national, on this issue I'm afraid I take the Anglo-Saxon approach, the common law approach. Trials in absentia are really problematic for common lawyers for lots of reasons, and the one experience that we've got of it, the Special Tribunal for Lebanon, frankly, has not been a happy experience. So my instinct, but of course I'm open to all argument, is to steer away from that issue. I'm really struck by what Anton and actually a couple of other colleagues said, is that the mere issuance of the power to investigate, an indictment, an arrest warrant has consequences. We know that has consequences. So the need to have someone actually appear, of course, in an ideal world, is what one should be aiming for, but that isn't the marker of success or effectiveness, in my view. Ratione temporis, I mean, it seems pretty clear to me that you cannot exclude what happened in 2014. It's part of a continuum. But of course, you've raised the question, Mr. Chair, and sitting next to our friend from Georgia, and I was counsel for Georgia in 2008 in the case before the International Court of Justice. It is to this day, at the time I described it as the worst judgment I had ever received from the International Court of Justice on a frankly ridiculous technicality, ruling that the court didn't have jurisdiction. And I think the court really needs to take account of its responsibilities for sending a very clear signal to Russia back in 2008 that you can do this and get away with it. And I suspect that the far-reaching nature of the Provisional Measures Order that Anton so successfully obtained with his very distinguished colleagues recently probably in some way has a connection with the court's failure in that early case. So I think, to cut to the chase, there is a real issue about how far back you go, and I suspect people in Georgia would feel pretty aggrieved in a sense that that issue is kept out. And separately, I sat for the first 2 days of this week in a hearing in an investor-state arbitration case as an arbitrator, in which the respondent state is Moldova. And in the coffee breaks, one talked, as one could appropriately. As an arbitrator, it's delicate, but with the colleagues who had come from Moldova. And I am acutely conscious of what is happening in that country right now and the very real anxieties. And as you said, Oksana, it is already partly an occupied country de facto. So I think there's a real issue to address. And finally, in relation to Belarus, I think it has to stay, this special tribunal, focused on the crime of aggression. I want to underscore, I think, what Carrie said, which is that the ICC, the Ukrainian courts, maybe the Polish and German and other courts, will deal with war crimes, crimes against humanity, and if it rises to that issue, genocide. But this institution must work very closely with the International Criminal Court. To my mind, and I strongly support the Council of Europe resolution, but it seems to me that if there's going to be a special tribunal, there's really only one place that it can be, and that is The Hague. It has to be in The Hague, and it has to be working alongside with, complementarily, to the ICC. Can I just say one final point, just listening to everyone? Going back to that moment when Alice Fishburne got in touch with me from the Financial Times, would I do an op-ed? One of the inspirations for me at this moment is I go back to 1945, and I go back to these two guys who spent the formative years of their lives as students in the city of Lviv, Hersch Lauterpacht and Raphael Lemkin. They were deeply and intimately connected with that city. 25 years later, they found themselves in the summer of 1945 cooperating with Robert Jackson and various other people. They did not know at that point about the fate of their families. It was silence, as it is for many people now in relation to Ukraine. They could have gone into a corner, curled up, and wept, but they didn't. They had ideas. They put those ideas into practice. They worked with the prosecutors, and they then prosecuted without knowing that the man they were prosecuting, Hans Frank, was the person who was indicted for the murder of their entire families. And that, for me, has been an inspiring thought. This is a most difficult time for our Ukrainian friends. We could all just say, oh, it's not important, oh, yes, there are other courts and tribunals dealing with it. But let's get to the heart of this issue. There are terrible crimes occurring in Ukraine, but there is only one crime that gets you to the top table. For countries to say, oh, it's going to cost half a tank or 2 tanks or whatever, and we're not willing to pay that, frankly, would be outrageous. And this is a special moment in European history, and we have to be up to the challenge of doing it. And being up to the challenge, and I'm going to come out here on the side of Eka rather than Carrie, it's not just about the narrow 2 or 3 people. It's about an inner circle, and in particular, the finances. Who is funding this work? They are part of the crime of aggression. So yes, let's take the ICC definition, but let's fine-tune it to make sure that we don't let other people off the hook. This is a vital moment, and I know that already I've been privileged to work with Ukraine and 5 countries informally in drafting. We've prepared a draft agreement, we've prepared a draft statute, that all exists. I really encourage those of you who are from other countries to say, you know what, this is the right thing to do now, and to step up to the plate and join this initiative. It's really necessary.
Thank you, Philip. And now Eka is raising her hand.
Very sort of on indictments, and then I guess in my own intervention I jumped into the judgments. I might dream of it too much, I guess, but then yes, I agree that indictments and then arrest warrants in that sense is more what I meant in the case of in absentia situations. But what would be important, and this is not something that lawyers frequently think about it when it comes to preparing materials and then indictments and imprisonment, sort of the arrest warrants, communication element of that. So if there will be only indictments and arrest warrants for some time, it will be very important to make them public in the right way without having trials, to have, you know, almost semi-trial, so to say, at least explanation what goes into indictment, what goes into arrest warrant, and then presenting evidences in that way, at least in this way, not fully as you do in the trials, but then giving that information to the public. So it's not just we were sitting somewhere there and then we found evidence for this and that, but explaining that, so that that gravity of the definition of what has happened and then what is the level of responsibility of any given, as an alleged one, at least, of individual, I think that would be important. So a bit creative way of looking into that could be important. And when it comes to Georgian position in that sense, I just want to clarify that indeed, ratione temporis, I mean, we would definitely see that that should include aggression against Georgia, but if it becomes an impediment in any way for the creation of the tribunal for the case of Ukraine, we would rather see the tribunal taking place and then be effective and set, because that will be some kind of indication in an indirect way for the past crimes as well for those who suffered. So it's important to move now, to be concrete and swift, and if anything complicates issues even further, then we were ready, at least I am personally, not to complicate it further. But when it comes to including or not annexation of Crimea, I would humbly submit that that is a very firm criteria in my perception, that it cannot be from the 24th of February of 2022, but then it needs to go well to 2014 for sure.
Thank you very much. Nobody else? So maybe only one question. No. Yeah, yes, please, from the audience.
Thank you very much. My name is Alan Kessel. I'm the legal advisor of Canada, and delighted to be here and also to listen to such eminent jurists and professors and the like, and especially at a very difficult time. But I do want to say something, and Philippe, I may want to take exception just for one thing you said, which was, which left the impression that some of us were not as engaged. And I want to say on behalf of not only Canada, which is very, very engaged in this particular issue, but many other countries which are our allies, spend 24/7 since this began in February dealing with this particular issue, that we are looking at every conceivable way to ensure that justice is arrived at, whether it be on the battlefield or whether it be on the battlefield of law. We're very much aware that the law is not going to be the determinative immediately, and therefore we are doing multitasking. But I do want to say to those of you who are analyzing and potentially thinking that we're just voyeurs on this subject, we are not. What I do think you need to do is get your story out in a way that you've done it today, and you need to be speaking to some of the other people who are out there. You do know that there are some serious legal questions related to the concept of aggression that have been around since the creation of the International Criminal Court. And I think a job that you need to do is try and figure out how do you allay some of those concerns. Some of you will be aware of the discussions that we had in the basement of the UN 2 years ago as we dealt with this issue. It was not pretty. But the reality is that it's still out there, and some of the major concerns related to it are remaining, and we would like to get over some of those. That's why we are supporting the International Court of Justice, and we're right there with the team, with the legal team. We're supporting the ICC, and we were there with the 43 others. We are supporting the Moscow mechanism, the OSCE. We're supporting the Human Rights Council and the agreement that's going to come out. And we're supporting every other report that is coming out on this in order to raise and continue the pressure that we need to. And, you know, we are with you in so many ways, certainly I have a full team who wants you to know that every single day we're working on this issue, and I can say probably for other of our allied governments that are here that this is not unique just to us. So take that message back with you as well, and we're certainly open to discussing further these issues with you. Thanks very much.
Thank you very much. And please.
Just,
please.
Alan, dear Alan, before you could please sit before you go. I think you understood that my words were not directed in particular to Canada. I've had a number of conversations with senior Canadians, and I am totally aware. I wasn't here, and I apologize that I wasn't here this morning, but there is an elephant in the room here, and let's address it. I know I was focusing on 3 members, permanent members of the Security Council. That's who I have in mind. And I know that there are elements within the permanent membership of the Security Council, Britain, France, the United States, who are thinking about this very seriously, and in some cases with a very open mind. Here is the issue. We know that, for example, recently, the British Foreign Secretary Liz Truss has said, basically, she supports the idea. And she's raised the issue that Alex raised, finance, resources, diverting stuff away from the ICC, which, frankly, is not a reason. We know what the real reason is. If the international community, or a part of it, creates, in the coming period, a special criminal tribunal for the crime of aggression in respect of 1 permanent member today, why could they not do it in relation to another permanent member tomorrow? And of course, there are other elephants in the room in relation to certain past military actions that I should best probably not name. That issue is going to have to be addressed at a political level. I've had private conversations with representatives of 2 of those 3 countries. The issue is, how do you ring-fence this decision? How do you create a basis for establishing a special criminal tribunal which allows you to really limit the risk of seepage? Because if you don't limit that risk of seepage and the creating of a precedent that could easily then be used in another context, and I'm sure we're on the same page, Alan, on this issue, there's no way you're going to persuade countries like Britain, France, and the United States to actively get involved. They haven't opposed it, and they're not going to oppose it. That's very clear to me. But I want them on board. I think they would bring a huge amount. And I'm open, Alan, privately, less privately, with anyone, to think through what is the delivery mechanism for creating this institution which brings maximum comfort, that it truly is only in the most egregious situations, such as this, that you open the door to such an approach. And I'm really grateful to you for your intervention, because it allows this issue to come out on the table. But having just been in Ottawa only a week ago and been so generously received, I can assure you Canada was not the subject of what you very rightly picked up.
Thank you. Thank you very much. And, I would like to thank and express our gratitude to all the panelists in this panel. And I have somehow to finish this conference in a few minutes, so my closing remarks would not take a long time. Of course, maybe it's not my own feeling, but actually I think we succeeded in achieving the main purpose. It's together it's the first conference, I guess, on the topic, so I believe there will be continuation somewhere in some places, but still our main purpose was to gather all of you who, first of all, signed the statement and the declaration, who also shares this idea, into one place after such a long pandemic time, and of course to a certain extent, what happened for me, it's also sort of fantastic, because when we started to speak on this idea, especially with Mykola. I can frankly acknowledge that it was, you know, at that time I didn't expect that you really would be able to come, because nobody actually knew what would be the development of the situation. So we're really happy, first of all, to have all of you here, and it is a good opportunity again to restore the networks that existed before, to create the new networks, and also to promote the idea of the justice that should be accomplished in this particular case, especially that actually all our civilization is at stake. So instead of making any conclusions, I just would like to ask you to support the text which is distributed here as the Vilnius communique. We would like to be mentioned somewhere as the place where the first conference was held, and I can read only maybe the final point of this communique, that the participants of the conference reiterate the importance for our and future generations of ending impunity for the core international crime of aggression against Ukraine, express support for all international and national legal efforts that have been undertaken in prosecuting individuals responsible for war crimes and crimes against humanity being committed in Ukraine, as well as for the necessity of finding an effective mechanism allowing to prosecute individuals responsible for the crime of aggression. Welcome the recent proposal made by the Parliamentary Assembly of the Council of Europe, encouraging urgently to set up an ad hoc criminal tribunal for investigation and prosecution of the crime of aggression committed by the political and military leadership of the Russian Federation. Call upon states to continue discussions on the possibility of ad hoc international criminal tribunal for the crime of aggression against Ukraine, and consolidate political will with a view of implementing the proposal made by the Parliamentary Assembly of the Council of Europe, and finally encourages creation, it's the most important, I think, for our conference, of international network of lawyers and academics to elaborate and advocate the idea of ad hoc international tribunal for the crime of aggression against Ukraine. I hope, you know, of course, this text will be still subject to language editing, but I think it reflects the main ideas that we can share, and I'm really would be thankful for your endorsement of this text, which also will be published. And finally, of course, I would like, on behalf of organizers and as minister, I would like to thank all the panelists, also who took part in the previous sessions. I would like to thank the distinguished audience also for patience, maybe, and also for your interest in this important topic. And I would like also to thank all the technical, organizational team for the organization of the conference. Indeed, it was, to a certain extent, a challenge to organize the conference almost in a month or so. It's not usual, let's say, for organizing international conferences. And also, I would like to thank our translators for a very important job to deliver messages and to making bridges between people who don't understand each other directly. So thank you all, and let me express our hope that this is the beginning of a huge job, actually, and we believe in success, and we are happy that we, let's say, made maybe the first small but significant step. And we hope that this initiative will be continued, will be promoted. We still need to pursue it. A lot of maybe skeptics, but for the sake of our future, we are obliged to do that. So thank you all.